Case on this morning's docket. That is case number 105228, State of Kansas v. Aldir Molina.
Counsel leave or just step out, or do you know?
I'm sorry?
Did your opposing counsel leave or just step out?
Oh, yes, it does help to have opposing counsel.
He's not used to brevity on the oral argument.
I'm Michelle Davis, and I'm here representing Mr. Molina. And may I please reserve 3 minutes for rebuttal?
3 minutes.
3 minutes would be good. This is a companion case to the case that was argued first this morning, so I think this court's well aware of the facts. We raised two merit issues in our brief. The court's failure to give a 6455 limiting instruction regarding evidence of other crimes, and then also the court's failure to instruct on the lesser of voluntary manslaughter.
And that would be on the marijuana possession and the attempted sale?
And some other things too.
Well, I'm just curious. It seemed to me that at the heart of Molina's defense was his argument that he was a drug dealer and not a murderer. So did he really want that limiting instruction?
Well, you know, Justice Johnson, the way I read the statute, 6455, is that if evidence cannot be admitted to show propensity to commit crime, it has to be admitted for a certain purpose. And the whole point of limiting instruction is to make sure that the jury understands to consider that evidence for that purpose. And obviously in this case, Mr. Molina is in the same way that the state introduced motive evidence. This was really Mr. Molina's explanation for why he was hiding from the police, that motive for his actions that day. And so he has a right to put this evidence in, but at the same time, it's very prejudicial evidence. And so in order to conform with the statute, the whole purpose of the limiting instruction is to tell the jury, don't consider this for his propensity to commit crime, consider it for this purpose.
What purpose should, what did you propose? I think you proposed what the instruction should have been, had it been, maybe
I did in my brief. I don't.
What purpose would the jury have been instructed? How would you distinguish between propensity and for the purpose for which it was offered, which was an alibi to show that he acted consistently with, that he was a drug dealer, essentially?
Right. Simply just say that this evidence was omitted to explain his actions that day. I mean, something along that line to explain why he acted in the manner that he did.
Pretty fine line.
Why he was hiding under the porch.
Right. That this was offered should only be considered by you for this purpose. And the state, in its brief, tries to make an argument that the defendant, when the defendant presents this evidence, it does not receive the protections afforded by the statute. But the state cites one case for that proposition, a case from 1970, it's Rawls, R-A-L-L-S, from 1973. And I don't really read that case for what the state's saying it was. In that case, the defendant got on the stand and he tried to say, I only have this prior criminal history. This is all I've done. And then the state, in impeaching the defendant, said, well, don't you have this further criminal history? So in Rawls, in 1973, the court said, well, this evidence was admitted for another, it was admitted independent of 6455. And of course, back in the day, a lot of evidence was admitted independent of 6455. And so they said, well, this didn't fall under 6455 because it was impeachment evidence. Now after Gumby, we don't admit evidence independent of 6455. And so that case I don't think applies. And so I think clearly, even though the defendant is admitting this evidence, it still should get 6455 protection. So I wanted to make that point. And then I think the other point to be made about this evidence is the difference between evidence that you're in a gang, which Golson says is not 6455 evidence, and then the holding of Goodson from this court in 2006, which says that if the evidence is related to illegal activities by the gang, the gang's illegal criminal activity, then that is subject to 6455 protection. And it's our contention that in this case, the young boy testified that he went to these meetings. The gang had these weekly meetings. And at these meetings, they discussed that if they ran into this other gang, that they needed to fight them. Or if they had a gun, then they needed to shoot them or to kill them. And so it's our contention, this is basically a conspiracy. This 12-year-old boy says, I know they're going to fight or shoot these guys because we've talked about it. This is what they're supposed to do. So to me, this is clearly evidence of illegal activity by the gang. And so the prejudice to the defendant is that you've got a jury saying, he's got a propensity to do this. There's a propensity here. And if he didn't do it before, he's going to do it again. It's just prejudicial evidence because it says these are criminals, this is what they do. They conspire to go out and hurt other gang members. And so, again, the state was admitting this for evidence of motive, and so the jury can be cautioned to consider it for evidence of motive, but not for propensity.
Isn't this different than the Goodson case, though? Because I don't think there was any connection in Goodson between the evidence of the gang activity and the actual crime, where here, Palomino, the 12-year-old, was essentially testifying about the type of gang activity that he had participated in and how that was relevant to this crime, or why he suggested, I believe, that he thought this was going to happen. The shooting was going to happen, and he was explaining why he thought that. So there was a nexus between that general activity and this crime.
Yeah,
and that's different than Goodson.
I think what helps my case, though, is the fact that he talked about we have these weekly meetings. And at these weekly meetings, this is what we talk about doing. And this is what we're supposed to do. So, I mean, clearly you have not just, well, he went to shoot. If they had talked about it in the car, well, there's our rival gang. So we're going to go shoot or kill them. And it was in the car, and it was just that night.
Well, he talked about that F-13 was a rival gang, and that they were expected to fight this rival gang.
But it wasn't what happened in the car that night, that discussion, where they said, well, they're in a rival. It wasn't part of this crime where they said it was a criminal conspiracy before this crime took place. It was evidence of a criminal conspiracy before this night in question.
The other thing about that is, it seems to me 455 by its very text of the statute requires, that the evidence be that a person committed a crime or civil wrong on a specified occasion. And we don't have anything here. Palomino just talked generally about these meetings and these two gangs. There was nothing specific at all about Molina, as I recall. So I'm wondering how it fits with the language of the statute.
Again, I would just go back to my argument that he was part of this gang. He was at these weekly meetings where there was this conspiracy. And I mean, Max made it clear that because they were going to do this because they were part of this gang conspiracy.
Did he even talk about whether Molina was at the weekly meetings when this was talked about?
Not specifically, but the way the evidence was introduced. I mean, the state made it clear that Molina was a participant.
In the gang,
Right.
generally.
And, yeah.
Isn't, this is what's troubling me about your argument, at least as to the gang evidence. It seems to me that motive, which you are conceding the state had the ability to introduce it for, is in these circumstances a kissing cousin to propensity.
Yes.
If your whole purpose in having a gang is to fight with other gangs, that's pretty close to just plain old motive, isn't it?
Yes. Yes, it is.
Okay.
But the problem is that the state painted such a broad brush here of this criminal enterprise that, I mean, that you have to try to protect the defendant in some way. But I agree. I mean, they were cousins. I guess the state could have tried to limit the evidence. There was no objection and there was no discussion of that to try to not paint such a broad brush, but that didn't happen.
But didn't Palomino hold the brush? Isn't it Palomino that testified that that's what we do? And that's what the F-13s do on Friday the 13th?
They go out and they hunt the SPVs. Right.
I mean, this, when you say the state painted a broad brush, the witness did.
Right, the
And
state's
there were no
witness.
objections to the
Right.
witness's testimonies.
Right, that's true. So I think, the second issue in our brief is the failure to instruct on voluntary manslaughter, and I can submit that on the brief. I think the parties have outlined that issue. And then there's several sentencing issues, if I may be allowed to move on, regarding the hard 50 sentence in this case. This was actually a hard 75 sentence. Mr. Molina was 20 years of age at the time this crime was committed, so with a hard 50, with 2 hard 25s run consecutive, it would be 70. At this point, he's eligible for parole when he's 95. The court used the fact that he had killed more than one person to justify a hard 50 sentence in one murder case, and then ran the second murder case consecutive to that, which then leads us to the hard 75 and parole eligibility at 95. We raised 3 issues in regard to that. One was that given the context of the ability of the court to run these crimes consecutive, the district court abused its discretion in finding that the aggravating circumstance was not outweighed by the mitigating circumstance, and in imposing a hard 50 sentence for one of the murder convictions.
Can you say that again? Are you saying the same thing for the consecutive as you are for imposing the hard 50, or are you distinguishing the discretion to impose a consecutive sentence versus the hard 50?
I think what I'm saying is, given that the district court could already run these consecutive,
Right?
that he abused his discretion in ordering a hard 50 in one case,
Okay, go ahead and explain that.
because he already had the ability, that it was an unreasonable act, because he already had the ability to impose a hard 50 sentence because he had 2 murder convictions that he can run consecutive, and that it was an abuse of discretion, that the hard 75 was not justified, is our basic argument.
Okay.
Given the mitigating circumstances of Mr. Molina, it knows were his young age, his worth as a person is shown in other circumstances. There was testimony he was a good father and a good son, and the fact that this was a gang culture. These killings occurred in the context of a gang culture. And then we presented an argument that was multiple punishments for the same offense, and I would just acknowledge the case law is against us on that. And basically, the case law on this is that the legislature has not shown intent not to do this, and so it can be done. And I would rely on the brief on that issue also, unless there are questions. And then the last issue is that the hard 50 statutory scheme is unconstitutional on its face, and according to a lien. And because the statutory scheme is unconstitutional on its face, he cannot be sentenced. The district court cannot sentence him to a hard 50 on one of the murder convictions. And I think this court's received plenty of information on this issue. So rather than summarize our arguments, I would, again, rely on the briefs that were done, unless there are questions from the court.
Any questions of counsel? Thank you.
Thank you.
May it please the court, Ed Brancart, Chief Deputy District Attorney from Wyandotte County for the state. With respect to the 6455 limiting instruction on the issue of the marijuana possession and sale, that evidence was introduced entirely by the defendant. The state had avoided that issue. The defense put it on in support of their theory of defense, explaining why he was in proximity to this shooting and caught hiding underneath a porch deck. In Gunby, at Head Note 7, the court speaks of Rawls, 213 Kansas 249. It's in our papers. Rawls demonstrates one situation in which we've already ruled that omission of a limiting instruction is harmless. In Rawls, the defendant introduced 6455 evidence during his own direct examination. We therefore held that he waived protection under that statute. So we're asking you to find similarly that if it was error, it was harmless in this case. We think that the,
Was there any other explanation of why they were saying that? I mean, do you have any textual information from the statute that supports that, or?
in the Rawls case,
Or
Your Honor, I
any-
don't. It has to be invited error. I mean, I would think that that's, if the defendant puts it in, he's inviting the jury to consider it. He can't use 6455 as both a shield and a sword.
He's inviting the jury to consider it for a limited purpose. Where does the invitation come to consider it as propensity evidence?
Oh, well, I don't know that we, from our position, Judge, we don't think it was propensity evidence. It was used to explain the inexplicable conduct by gangs. What would explain somebody pulling up next to a car on a public street and just opening fire into it, other than this gang culture? And to the extent that it was, you know, the lay juror wouldn't know those things. It was introduced to explain an otherwise inexplicable act. We didn't offer it for propensity. And I don't know if that answers your question, but that kind of evidence has been ruled admissible independent of limiting instructions a number of times. It didn't explain, Palomino didn't talk about other crimes. He talked about motivation for doing the crime that night. So we think that it doesn't qualify as 6455 evidence on that basis as well. There was information about a stolen car, and there just simply wasn't evidence, and certainly not in the briefs, to demonstrate any way that one could hold Molina accountable for that. Nothing to indicate he knew a car was stolen, nothing to indicate, I mean, he was a passenger. He wasn't exercising dominion or control over the car. It just wouldn't qualify for the kind of use that is complained of in the defendant's brief. The weekly meetings, Your Honors, we think were teaching, not getting together and agreeing to commit a future crime. We have briefed those issues, and as we have voluntary manslaughter, that's submitted to you on the briefs. I don't have any problem submitting it to you on our briefs. The hard 50 issues, we have briefed on supplemental. We maintain that Alene does not render our hard 50 statute, the pre-Alene statute, 214635, unconstitutional on its face. In this situation, we have a judge who has had a jury find beyond a reasonable doubt that the defendant killed 2 people. And that would meet the requirements of Alene. There was indeed then, the judge built a pretty good record about how he was weighing aggravators and mitigators, and explains that.
But the judge here specifically mentioned that Molina was the shooter, that he wasn't the aider and abettor. And on Lopez, the other companion case, he did use the fact that he was just an accomplice as a mitigator. So why isn't that making a finding? The aggravator is that you committed a felony in which the defendant inflicted death, right?
Inflicted or caused great risk to bodily harm.
Okay.
And so I think that the twofold portion of that aggravator makes it possible for aiders and abettors to be included. All of the evidence in the case that we're now on suggests that.
But that didn't happen here. The judge did it just the opposite. The judge used the aider and abettor on Lopez as a mitigator, that he was just the accomplice, he wasn't the shooter.
And then weighed that nonetheless he was.
And the point we're getting at is whether the convictions automatically establish the aggravator.
as
Isn't that
applied.
what we're after here? Whether the judge has to look at anything more and make any other determination as to whether the journal entry that you pick up and look at, whether they have to look at any other facts?
Well, certainly I understand the pursuit of that answer to that question. In Molina, as applied, the judge had the convictions, and Molina was the shooter. He turns out the aiding and abetting isn't really a factor for Molina. Even if it were, Judge, I think that we could make a compelling case to you that aiders and abettors are charged and convicted as principals. An active aider and abettor, such as Lopez in this case, he facilitated this crime. He was a part of it. Differing from a solicitor or a conspirator who may have been somewhere else at the time. Our law is pretty complete about that. I think the Cunningham case from 85-ish says that that very phrase, that they're prosecuted as principals. The rest of our law says that aiders and abettors are held accountable at the same level of severity for punishment purposes.
I understand criminal responsibility, and in fact, we have a statute that deals with that and says criminal responsibility. But what we're talking about right here is whether the judge has to do anything more than just look at what the jury found.
Yeah.
Aren't we? I mean, that's a real issue here.
Yeah, he's obligated to weigh, certainly. I acknowledge that. A lien seems to give the preserve for the sentencing judge the authority to do that. They were very careful in saying, while we require elements to be proven by and found by proof beyond a reasonable doubt by a jury, we're cautious to say that we're not trying to intervene on a sentencing judge's exercise of his discretion. And I know in a lien they use the term fact-finding, and I think in context it had to be a term of art. It's the only thing left to do after the jury has made its findings with respect to the elements that are aggravators. And the court had to be referring to the weighing process in the various states when it used that phrase. We think that district judges in Kansas under our pre-lien Hard 50 statute are not obligated to sentence the Hard 50 if there's an aggravator that outweighs mitigators.
What does shall mean?
Well, I follow that, Judge. 4635 has 4 parts. And I think you're referring to the 4th part, subsection D. And there's also subsection B, which, as I read it, is clearly saying that district judge shall first determine whether to issue a Hard 50 or to sentence otherwise by law. I've paraphrased there, perhaps even inartfully. But you can't, I think you got to go through B before you get to D. So one, there's an argument to say in the order in which it came, that's the first decision. If you don't follow that,
And
you
the
can't
B
do D.
language, you're saying when it says the court shall determine
Yes, sir.
whether to impose the Hard 50, that means that the court has unbridled discretion?
Well, it confers upon the court the discretion to order a Hard 50. And then
No, it
detail.
says the court shall determine.
Well, shall determine, yes,
Yeah.
sir. And that means shall decide, shall make a decision. It doesn't mean he shall sentence. It means he shall determine which of those options to sentence. And in fact, Judge Johnson did that very same thing here. We have 2 counts. And the first one, he said, I've weighed, I've balanced, I find that the aggravator is present, and because the jury has found you killed 2 people, the evidence is you were the shooter. That outweighs the mitigators that you offered, and I sentence you as the state urges to a term of 50 years, minimum term of 50 years, life with parole eligibility at 50. Then he went on to count 2. And he said, you know, even though I believe I have authority to sentence you to another hard 50, the state doesn't urge it, and I don't. He only sentenced to a hard 25 on that one. So in this case, the judge exercised that discretion. He didn't feel compelled to have to order a hard 50 on both. I note that the defense, in their initial briefing here, asks you to consider that Judge Johnson's weighing as an abuse of discretion. To us, that means even the defendant acknowledges the judge was exercising discretion. And we follow that up by noting that the defense is not asking you to send this back to add on another hard 25 to make the second one a hard 50. The defendant is perfectly happy with the exercise of discretion. So we don't think that subsection D requires it. What we interpret subsection D to mean is it's a one-way valve. If the judge in B determines to issue a hard 50, he has to do it according to subsection D. And if the jury has not given him, if there's no evidence of an aggravator, then he can't do it. Which I think is a bit of I've kind of been watching the arguments in these cases, and I'm not sure that point has been made before.
Right.
So what you're saying here on count 2, even in spite of the aggravators still outweighing the mitigators, he just chose not to impose the hard 50.
That is correct.
And exercise discretion that you believe is in the statute, even though D says shall, once that equation is made.
I do, Judge. I don't think you can read D without B. It's either B comes first or they come together. You can't do one without the other. We're asking you to affirm the conviction and uphold the sentence. I haven't spoken about retroactivity, and I frankly want to convey to you from my district attorney that we're asking you to affirm. We included that in our briefs because we don't want to waive an argument, but it does seem, after we've watched Hilt and Astorga, and certainly involved in this case, that if you don't uphold, let the lawyers be lawyers, let the district judges be district judges, and if a matter comes back to you, then wrestle with that issue.
I just want to make sure I understand there's clarification here. We were talking earlier about, I think we were talking about a different section, the one that's at issue in Astorga, the aggravating circumstance. Here we're talking about that the defendant knowingly or purposely killed or created a great risk of death to more than one person.
Yes, sir. Yes, ma'am.
And
Not
so,
the
yeah.
not the prior conviction.
Right. And
Yes.
so, and your argument is that that was clearly found by the jury as the judge found it was found by the jury, and that there's just no way to look at that as anything other than a factual determination made by the jury that would satisfy Alene.
Yes, the jury made that finding by proof beyond a reasonable doubt.
So that
As applied, then it's okay.
as applied.
And because it's possible of that, our statute was not unconstitutional on its face.
Right.
You could conceive of examples where it would survive, and this is one of them.
Right. This would be the reason that you could answer both questions, essentially. On its face and as applied, this is the case that shows that it's potentially, if your argument
Yes,
is
ma'am.
successful, that it's constitutional on its face and as applied.
Yes, Your Honor.
And that's assuming that we find that the weighing process is not a factual finding. Because
Certainly.
even if the jury finds 2 deaths,
It's a necessary component of your argument.
the process requires that the mitigators not outweigh the aggravator and requires the court to do that. And so your argument supposes that that's an exercise of discretion rather than a fact finding.
Yes, sir.
Okay.
An exercise of discretion properly lodged in the court, not in the jury.
Yes.
That's a necessary component of your
And as
argument.
we believe is approved by Alene when they make that exception that says, we want to be careful to announce what we're not saying today.
Any further presentation?
Thank you all.
take
Oh,
it
no,
your answer
no,
is no?
no.
You
I
have
thought that was a
no-
question about any other questions. No, no further presentation, Your Honor.
Any other questions of council? Thank you, council.
Thank you.
I just want to clarify that the state did not request consecutive hard 50 sentences in this case. This was not a situation where the court declined to do it. The state just didn't request it. And I just refer you to volume 12, the sentencing transcript, page 39. And the state says, we want to recommend, all the evidence came in about aggravating, mitigating. The state says, we want to recommend the hard 50. And then the state says, we want consecutive sentences. And the judge says, but you're not asking for consecutive hard 50. And the prosecutor says, no. Hard 50 on the first count, hard 25 on the second, and it goes run consecutive. So this was not a situation where the court somehow declined to impose. And again, the state, this is within the power of the state to
I don't
ask or not
understand
ask.
that argument, because if the statute says shall, then it's shall, and it really doesn't matter what the state argues.
Well, the state has to bring a hard 50. The state has to give notice and request it. So this could be a case, there are plenty of premeditated murder cases where the state just doesn't ask for it. So in this case, it's our contention the state didn't ask for it on the second count. The state only requested it on the first count.
Any further presentation? Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.